Our next two speakers are going to round out the day. They're last but absolutely not least. They're phenomenal topics and phenomenal speakers. Our next topic will be presented by David Steele, and it's the topic of business trusts. It's a topic, to the best of my knowledge, that hasn't yet been presented to the estate planning bar, but one that I think a lot of you are going to find of great interest. More and more trusts are being used in the commercial context, and they give rise to the traditional issues relating to trusts, when they're put in the commercial context, give rise to some very, very unique problems. And David's going to talk to us about those problems and the issues that arise. David is a partner with Torrey, Delory & Binnington, specializing in estate planning administration. He does work in the charities and trust area as well. He's a member of not only the Ontario Bar, but also the New York Bar, and he's taught courses at Osgoode Hall Law School, and he is a member of the International Estate Planning Committee of the New York State Bar, and is on the executive of the Trust and Estate section of the CBAO. He's published articles in a variety of different journals, including Estates and Trust Journal, Canadian Family Law Quarterly, and Canadian Business Law Journal. Welcome, David.
I know I'm going to need this microphone. I'm laboring under about the third cold I've had already this season. I've got a 3-year-old son who feels that I need to test my constitution at least once a month with some new cold strain. And I don't know what I've got presently, but it's certainly causing me a bit of loss of voice. So I apologize beforehand, and I'll try to labor through it. As Elena pointed out, my paper is on business trusts, or more specifically, I've titled it Some Key Issues for the Trust and Estate Practitioner. And I thought what I'd do in the time I've got today is to give a little bit of a survey of what the paper is about. I obviously don't intend to read the paper or cover everything that's there, but I thought I'd try to give you a sense of what's covered in the paper in case it's of interest to people here. But I think I was keen when Elena called me to give the talk, because at least my own anecdotal experience has been that in addition to traditional trust and estate practice, in the last couple of years I've been spending more and more time working with my commercial law colleagues on transactions involving both what I might term business trusts and more conventional family trusts, but also becoming involved in opinion work and in creating trusts that are created solely for the prosecution of some kind of commercial activity. And I've found this at a personal level to be particularly interesting and a nice distraction from maybe traditional trust and estate work. And it's also been my sense that I'm not alone in the shift I'm seeing in my own practice in terms of an emphasis on commercial trust matters or business trust matters. And I know that there's a number of people here that I see today who I've encountered fairly regularly on business trust files. So my sense is that, that this may be a timely topic. I guess there's two aspects to it. One is it's been an interesting diversion. Whether or not the business trust is something that's sui generis, unique and different from the family trust is debatable, I suppose. But I think it's quite clear that business trusts do present a range of issues that you don't see in dealing with more conventional family trusts, including issues relating to things like liabilities to third parties, and as well issues relating to beneficiary liability, which are two of the topics that I spend a fair amount of time on in my article. One thing that is, I think, quite clear about business trusts is they are proliferating in Canada. Of course, we've seen an incredible expansion in the number and diversity of different types of pooled investment trusts, including things like mutual funds and real estate investment trusts. As well, we're seeing more and more trusts used in the context of securitizations, environmental reclamation projects, all kinds of different areas that I think present an interesting opportunity for the trust and estate lawyer to get involved in. I'm not sure what the experience has been in the States in terms of the involvement of trust and estate lawyers. in this kind of practice. There was an article in the Yale Law Journal just a couple of years ago by Professor John Langbine in which he seems to be of the view that trust and estate lawyers generally have not become involved in this kind of work, and that issues relating to business trusts have essentially grown up in the context of very specialized bars like the securitization bar and the managed assets bars. And he may be right. I don't know the American experience well enough. Some other commentators have recently begun to suggest that the whole area of business trust is becoming a specialization in its own right, something separate both from the traditional trust and estate bar and from the commercial law bar generally. There's been a recent UK treatise published on business trusts, and this may be the shape of things to come. But in Ontario, and at least for the foreseeable future, it seems to me that there's a role for the trust and estate lawyer to play, and that was really why I became interested in giving the talk. The first section of my article really focuses on an attempt at defining what a business trust is, and that's not an easy thing to do. I think people use the term in different ways, but I think generally speaking, Tim Youdan, who's the next speaker here today, was right when he pointed out in an article a few years ago that there's no technical definition of a business trust, and that the term is used to cover a variety of trusts, including mutual fund trusts, pension trusts, and other trusts providing employee benefits, trusts used in the context of securitization arrangements, real estate investment trusts, and more generally trusts which engage in trade or business. I think there's probably two key points to note in terms of thinking about a definition of a business trust, or thinking about what it is that business trusts are. The first is the perhaps obvious point that a business trust is a trust. And so, like any other trust, it has to satisfy the familiar requisites for creation. You have to have your three certainties, you have to have constitution, and so on. And this will seem obvious and trite, but when you're placed in the role of opinion giver in the context of a commercial transaction, perhaps where the trustee of a business trust or the trustee even of a family trust is perhaps the vendor or purchaser of assets or shares, these are things you're going to have to focus on very, very carefully when it comes to delivering the opinion that the trust has been duly settled and is continuing under the laws of the province of Ontario. So trite point, but an important one. I think a second point to make is that because a business trust is a trust, like any other, it's not a legal entity. And this is such an obvious point to everybody here today that you probably scratch your heads, unless you practice with commercial lawyers. And if you do, you'll know that this fact is a great mystery. And the root of the misunderstanding often comes through in a fairly subtle way. And in my practice, it always comes with the same phone call, usually on the eve of closing, when somebody calls me and says, "How does a business trust sign an agreement?" I always know that this is a sign of a deeper and more serious problem. And I think, obviously, the problem is that there's an assumption that the trust is somehow an entity and that the trust can itself have obligations and acquire rights. And also the notion somehow that the trustee is acting as an agent on behalf of this mysterious creature, the trust. And that is certainly a recipe for problems. Again, I think probably at the end of the day, the better view is that at least under Canadian law, business trusts are not sui generis, and that really what the business trust represents is just the flexibility of the traditional trust concept that comes to us from the law of donative transfers being applied in commercial settings, and its flexibility proving useful in commercial settings. And I think most commentators would agree that many of the characteristic elements of typical business trusts are nothing unique or unusual. They're all things that are either permitted by general trust law or really are demanded by general trust law. And here we think about things like limited liability of beneficiaries, ability to freely transfer beneficial interests, and so on. Even accepting that the business trust is not something that is sui generis, I think a difficult question remains, and that is to what extent traditional trust law principles ought to be applied without modification in commercial settings and to business trusts. It's my sense that there's been very little Canadian law that has considered this issue, In fact, it seems to me that there's been very little law in the Commonwealth on this issue, but there's been some interesting suggestions in recent English cases as to how this might play out. You might recall a number of years ago, there was the well-known case of Cowan and Scargill. This was the famous mine workers' pension case. It was a chancery decision, and in that case, the court said that although it's true that there are many things, and this involved a pension trust, although it's true that there are many things that are unusual about pension trust or that are distinguishable from a typical family trust, and here you might think primarily of the fact that persons who participate as beneficiaries in a pension trust arrangement are in a very real sense purchasing their interest. The court in that case concluded that that fact, these aspects that distinguish the pension trust from a typical family trust don't compel you to conclude that there should be some relaxation of traditional trust principles in the context of pension trusts. However, more recently, there's been a case called Target Holdings Limited and Redferns that went to the House of Lords, and the case involved a consideration of whether certain rules relating to the award of damages for breach of trust would be applicable to a bare trust in a commercial context. But in the course of the reasons for judgment, Lord Brown Wilkinson, for a unanimous House of Lords, made some very interesting comments in dictum about the application of traditional trust principles to business trusts. He said, and I quote, and this is in the article, "It is wrong to lift wholesale the detailed rules developed in the context of traditional trusts and then seek to apply them to trusts of quite a different kind." He went on to say that it's important, if the trust is not to be rendered commercially useless, to distinguish between the basic principles of trust law and those specialist rules of trust law developed in relation to traditional trusts which are applicable only to such trusts, and the rationale of which has no application to trusts of quite a different kind. Those remarks have been cited with approval in a number of subsequent cases, but I don't think there's really been any attempt to flesh out which rules might be suspended or modified in the context of commercial trusts in any meaningful way. So I think clearly the challenge going forward is for courts and for people representing or involved in business trust work to try to distinguish between what might be termed the basic principles that are going to apply to all trusts and those specialist rules that are unique to personal or family trusts. From my own perspective, I think the approach of Lord Brown Wilkinson is certainly to be welcomed. I think it's a good idea to take commercial context into consideration in analyzing trust problems. I was talking to Tim Youdan before giving my talk, and I've been scratching my head a little bit as to what might be a good illustration of a circumstance where you've got a rule that has developed in the context of traditional family trusts that ought not to be carried wholesale into a commercial trust context. And the one that occurred to me is the principle that arises from the case re Londonderry settlement. And that principle, I think, maybe could be shortly stated as trustees are not obliged to provide trust documents to beneficiaries in circumstances where the trust document reveals the reasons behind an exercise of a particular discretion. And I think you can rightly debate whether or not that's a sensible rule even in the context of family trusts nowadays. But that being said, a couple of years before the decision in Target Holdings, the issue was considered in the context of a pension trust in another UK case called Wilson and Law Debenture Trust Corp. And really with very unsatisfying analysis of the issue, the Chancery Division in that case just concluded that the re Londonderry settlement principle ought to be carried through to pension trust. But that seems to me a suspect proposition in a context where you have beneficiaries who have actually purchased their interest in some way. It seems like a very paternal approach to say that somehow the trustees ought to be sheltered from disclosing these documents that are clearly relevant to the participants in the pension arrangement simply because it reflects the reasons behind the exercise of a particular discretion. It seems to me a protection that arguably ought not to be extended into commercial context. Anyway, that was the only illustration that I could really think of in the short term. The next part of my paper really focuses on a very brief consideration of why it is that business trusts are proliferating, and they clearly are. I mentioned at the outset that they're clearly expanding both in terms of numbers and in terms of types in Canada. I think it's hard to get a real sense of the extent of that, but there's been some analysis done both in the United Kingdom and in the U.S., and the estimated number that I've heard is that of all wealth held through trusts, it's likely that about 90% is held through business or commercial trusts as opposed to traditional family trusts. So again, from a very selfish trust and estate lawyer perspective, that is a big market for us to get involved in. But what are the key reasons for this expansion? I think one is the insolvency protection element. That is that the happening of the bankruptcy of a trustee does not necessarily have implications for the beneficiaries. Personal creditors of a trustee won't have access to the trust property. In commercial lawyer slang, this achieves bankruptcy remoteness. I think you only have to consider the pension context as a good illustration of why this might be attractive. And if you contrast the situation where an employer simply gives a bare promise to provide a pension benefit as opposed to a pension arrangement that is funded through a trust where the employer becomes bankrupt, I think it brings into pretty stark effect the difference in the situation of the participants in the first type of unfunded, untrustee arrangement and in the latter pension trust case. The next, I think, big reason for the proliferation of business trusts is flexibility in design. I think the fact that the commercial trust or business trust emerges from the law of donative transfers probably accounts for a lot of the flexibility that is there when it's introduced into commercial setting. It allows a great deal of flexibility in defining the creation of beneficial interests. I think a related point is, of course, that business trusts and trust law reduce a layer of regulation. There isn't an equivalent statute to the Business Corporations Act that imposes meeting requirements and other formal requirements in terms of both the design and administration of a business trust. And this can be very attractive. I think it can also be correspondingly intimidating. I think some commercial lawyers may feel that in designing a vehicle, they would rather go with the familiar and they're more comfortable in having a statutory code. But I think as familiarity with the trust concept grows, this has been one reason for the expansion of the concept. A final reason, and there are of course many others, has been described as access to fiduciary rules. And by this, as one commentator has expressed it, the theory is that by using a trust in commercial setting, you're automatically invoking the distinctive protection regime of trust fiduciary law for safeguarding the interests of investors or other beneficiaries. And this is seen to be a useful policing mechanism in a commercial context. The next section of the article, which I really won't spend any time on at all, is an extended description of 4 types of business trusts that are in fairly common use in Canada. The first being the mutual fund trust, the second being the securitization trust, and then finally the pension trust and the voting trust. And the intention in this part of the article was really to do 2 things: to give some sense of how these fairly familiar forms of business trusts are organized, and as well some sense as to how they're employed in different commercial settings, to give some context really to the balance of the article. What I then did in my article is really to focus on 2 issues that seem to come up fairly frequently in my own practice. There are certainly others in the context of business trusts, but 2 issues that came up a lot and that pose problems. The first is the whole issue of beneficiary or unit holder liability under business trusts, and the second is the issue of third-party claims against trust assets in business trusts. The beneficiary liability issue is likely one that's had more attention and probably has been certainly given more consideration by the courts in recent times, it's probably the easier of the two issues to talk about. The beneficiary liability issue is particularly crucial in the context of investment trusts, where the ability to sell an issue of units in a mutual fund or in a real estate investment trust, where it seems to come up very acutely because of concerns about environmental and other liabilities, is really the ability to market the issue of the units is going to depend to a very large extent on the ability to include in the prospectus or the offering memorandum a statement that the risk to unit holders in making this investment is going to be minimal. And of course, the ability to include a statement like that in the prospectus or the offering memorandum is going to depend on the ability of you and me to give a legal opinion that that risk is going to be remote in the circumstances. And so it's a pretty key issue and one that you're likely to encounter if you haven't already. Just a quick synopsis of how it works. Of course, the basic rule, as we all know, is it's subject to the terms of the trust instrument. Beneficiaries of a trust do not, in their capacity as beneficiaries of the trust, have personal liability. There are, of course, a variety of qualifications to the general principle that I tend to think about in two categories. One I might term sort of indirect liabilities, and by this I just mean there are circumstances where the beneficiary of a trust will have an obligation to indemnify the trustee in respective obligations that the trustees incurred. And this one can be a particular concern in the context of investment trusts. The old principle from the Hardoon and Belilius case that's probably known to many of you can be an issue here. Nobody, I think, quite knows the extent of the indemnification obligation that flows from that case, but certainly it has a potential application to business trusts and investment trusts. But it's relatively easy to deal with and is routinely dealt with through the trust instrument that creates the business trust. There will be an express denial of any recourse by the trustee to the beneficiaries, and the authorities make it clear that that's going to be effective to exclude that risk. So I think the risk that one tends to focus on more, and probably rightly in the business trust context, is the risk of direct liability. This is the case where a creditor is able to make a direct claim against the beneficiary on some theory. And of course, a lot of you here will remember the debate that Morris Cullity, as he then was, had with Robert Flanagan in the pages of the Estate and Trust Quarterly some years ago on this issue. And it might be worth just spending a minute recapping that debate. Professor Flanagan was of the view that, largely based on some American authorities, or considerable American authorities, that if you give a beneficiary certain kinds of powers, or too many powers, in connection with the administration of a trust, you run a risk that the beneficiary is going to be treated, or that the trustee is effectively going to be treated as an agent of the beneficiaries, thus resulting in direct liability to the beneficiaries. And there certainly is a body of U.S. law that points in that direction. Morris Cullity, on the other hand, said that he didn't say that control was irrelevant, but what he said was that there really wasn't any Anglo-Canadian authority that supported that view, and that the most that one could say, at least in Canada, was that the only instance in which control by beneficiaries would become relevant would be in the circumstance where you're dealing with a bare trust. And by that, he means a trust under which the trustee has no real positive independent obligations or powers. And the issue, of course, becomes they had their debate. What happened? We had the well-known case in Ontario that went to our Court of Appeal in Trident Holdings and Denand, which involved basically a syndicated real estate project where you had a trustee holding on what was very clearly a bare trust arrangement for the benefit of a number of corporate participants. And in that case, the court concluded that based on the documentation, there really was no intention to create an agent, or there was an intention to create an agency relationship between the beneficiaries and the trustee, and didn't have any difficulty in imposing liability on the beneficiaries where a creditor claim arose out of a breach of contract by the trustee. But unfortunately, in that case, the Court of Appeal went on to quote from Professor Scott's work, Leading American Treatise on the Law of Trusts, that does discuss the control test. I think at the end of the day, there was no indication in that case that there was an intention to suggest that the control test would have any application beyond the context of bare trusts. But it was a bit unfortunate that this U.S. analysis got imported into the case. Subsequent cases in Canada that I've noted up suggest that the control test has not been expanded in Canada, and the only circumstances where we've had this principal agent issue has been in the context of bare trusts. So that seems to be the current state of the law. Third-party claims against the assets of business trust. I think am I doing okay on time, or got a few more minutes? This is the more difficult and I think more interesting issue to me in any event. It's a very complicated issue. And the basic question here is you have trustees that are entering into a variety of transactions with third parties in commercial settings. And if you talk to any commercial lawyer, I will assure you that both those acting for the third party and those acting for the trustee will always be of the view that there will be direct recourse to the trust property. I'm yet to meet a commercial lawyer who doesn't think that. The question is, to what extent is that true? And of course, the conventional wisdom is that basically the claim that a creditor of a trustee will enjoy to reach the trust property, if at all, is a derivative claim. And the thinking goes something like this. When a trustee contracts with a third party, the trustee does so as principal, and so that any liabilities that the trustee incurs are liabilities of the trustee. Now, the trustee will have a right to indemnify itself from the trust assets if the trustee has acted properly, and so long as the trustee is not somehow independently indebted to the trust. And so if the trustee's own assets were insufficient to meet the creditor's claim, let's say, the creditor would have a derivative right or a subrogated claim in equity based on the trustee's own right of indemnity. So that if the trustee would have been entitled to indemnify itself out of the trust property for the obligation that it incurred, the creditor will enjoy that right. But if that's the only instance in which you get direct recourse, it's very unsatisfactory from a commercial standpoint, clearly doesn't accord with the reasonable expectations of the parties, and clearly puts the party who contracts with a trustee in an extremely vulnerable position, because the authorities on the derivative claim suggest that a later action by the trustee that was improper and resulted in the trustee being indebted to the trust fund would impair the earlier creditor's right of recourse through the subrogated claim. So it puts the third party in a very difficult position. How can you deal with it, and what other ways are there in which you might have direct recourse to the trust property? Well, one obvious way is if the trustee has the ability to grant security under the terms of the trust over trust property, either as a floating charge or over specific assets in the trust, one option for the creditor, the would-be creditor, will be to take security. The issue that arises, though, is that if it's not possible to take security, what else can the creditor do, or what other rights may the creditor have? Canadian law in this area, particularly in the context of business trust, is, I think, completely undeveloped. And so I think we have to look to other jurisdictions to see what's been happening. And one jurisdiction in which a great deal has been happening is the United States, and there's a fairly clear recognition of some exceptions to this subrogated claim theory. One exception is what I've termed in the paper a restitutionary exception. And this is the case where if a third-party creditor enters into a transaction with a trustee, even if that transaction is improper from the standpoint of the trustee, if the third-party creditor is conferring a benefit on the trust estate, for example, is making a loan to the trust estate that creates an enrichment in the trust that enriches the ultimate beneficiaries of the trust, so long as the lender wasn't aware that the trustee was acting in breach of trust, these U.S. authorities, and indeed some authorities elsewhere, suggest that in that circumstance, based on a restitutionary claim, the creditor will have a direct right of recourse that is not tied to a subrogated or derivative claim. That's a pretty limited right when you think about it, because the extent of your recovery, if you're acting for the third party, is going to depend on the extent of the enrichment rather than the extent of your damage, the harm you've suffered. And it's also not a particularly comforting basis on which to give an opinion that an obligation that's being incurred is valid and enforceable in accordance with its terms. The next exception, in a very important one, I've termed the trust instrument exception. And this exception, again, largely based on American authority, suggests that where there's a provision in the trust instrument that states that the trustee shall not be personally liable for expenses incurred in the administration of the trust, but rather that any creditors will have a direct right of access to the trust property, has been recognized as being enforceable in the U.S. and as giving to the party who contracts with the trustee a direct non-derivative claim. In that context, though, I think that the person who's contracting with the trustee, even though it's not dependent on a derivative claim, I think the person who's contracting with the trustee still has to satisfy himself or herself that this is a proper transaction and that the trustee at least has the power to enter into this transaction in order to get that protection. The final exception that I was going to talk about is what I've termed the contractual exception. And this is an exception that arises where, in the terms of the agreement between the trustee and the third party, the terms of the contract state that the other party, the non-trustee party, shall look only to the trust property for recovery and shall not obtain any satisfaction out of the trustee's own property. There's two ways, clearly, and the cases indicate there's two ways to interpret a contractual provision like that. One way I might term the narrower approach, and under that approach you would say, or the courts have said, that what that provision means can't be interpreted literally. It doesn't give the creditor, it doesn't give the third party a direct claim against the trust property. What it does is exempt the personal property of the trustee. So you can't have any satisfaction out of the trustee's own assets, and your only recourse is going to be, again, dependent on the integrity of the right of indemnity that the trustee has. Again, that's certainly the narrower approach, and clearly, in my view, does not accord in any way with the expectations of the parties. The second approach, which has been quite widely employed in the U.S., is to interpret a provision like that that exempts the trustee's personal assets from liability as giving a direct non-derivative claim to the third party to reach the trust property. And again, I think the person who's acting for the third party in this case, at a minimum, has to be satisfied that this is a transaction that the trustee has the power to enter into in the circumstances in order to get the support of that contractual exception. Final section of my article, which I really will only touch on extremely briefly, is a consideration of legislation called the Delaware Business Trust Act. I became interested in the Delaware Business Trust because I just found I was encountering them more and more frequently, and they're very peculiar animals. By the statute, these, quote, associations are actually given legal entity status. And the legislation goes on at great length to try to deal with a couple of these problems that we've discussed today. It expressly says that no matter how much control a unit holder or beneficiary exerts over the trustee, that there won't be recourse to the personal assets of the beneficiaries. And then on the issue of recourse to the trust property, it says very clearly that the trustee shall have no personal liability unless the trust instrument says otherwise, and that any claims to be asserted by a third party can only be asserted directly against the property of the trust. It's a very interesting statute. It clearly, from a commercial lawyer's perspective, it's an attempt to make the trust concept look a lot more like a corporation, to make it a more palatable substitute for use in commercial settings. Very interesting piece of legislation. I guess the one question for anybody who reads it to continue to ponder is whether or not a Delaware business trust is really a trust in a common law sense, which could have, I think, significant implications for Canadian lawyers who are involved in transactions with Delaware business trusts. I've probably gone over my time. I'm certainly out of wind. Thanks very much.
Thank you, David. That was a courageous talk in light of your cold, and also very comprehensive coverage of a very complicated topic. Our last but not least speaker is Tim Youdan. If you don't know by now from having heard him speak, Tim hails from the United Kingdom, and he's worked on both sides of the border of the ocean. He's a partner at Davies Warden Beck, having joined them in 1992 and become a partner in 1994. Tim has published extensively. He's authored The Law of Family Property. He's editor of a number of publications, including Equity, Fiduciaries and Trusts and Estates and Trust Reports, and has consulted with various government bodies, including the Ontario Law Reform Commission. He has, as I mentioned, both practiced law and taught at universities both in Canada and the United Kingdom. And he will speak to us today about variations of trust.
Thank you. It is still Davies Warden Beck. You said Tory, Delorier, and Binnington. I thought that perhaps was the shortest merger of two law firms there's ever been.
You know what? He didn't change his
CV. Okay. Variation of trust. The little paper I've done is mainly a summary of some cases. I'll try in this brief talk to make some more general observations. And before I get into the particular topics that I touch on in the paper, I want to make a few general comments by way of background to the variation of trust legislation in Ontario. The starting point is, I think, the rule in Saunders against Vaudier, the rule that beneficiaries can override the intention of the settlor as set out in the terms of the trust and terminate a trust if they're all adult, all competent, and together absolutely and indefeasibly entitled to all of the beneficial interests in the trust. If you're able to operate the rule in Saunders against Vaudier, you can effectively terminate and recreate the terms of the trust as you choose by agreement. Before the Variation of Trusts Act legislation was passed, there were, and there still are, certain heads of inherent jurisdiction that the court has to cause trust to be varied. Those are quite limited in scope. One of them, the so-called compromise jurisdiction, was being used extensively in the early 1950s, in England in particular, on a broad basis, so that courts were varying trusts even when there wasn't a dispute, in order to effect a change of the respective interests of different beneficiaries on the basis of supposedly this compromise jurisdiction. Most of those variations being done then, as they are now, to deal with the incidence of taxation, which in the 1950s in the United Kingdom was at extraordinarily high rates. In 1954, in a case called Chapman against Chapman, the House of Lords held that the compromise jurisdiction didn't permit what had been going on, but only applied when there was a genuine dispute. That is what led to the passing of the Variation of Trusts Act, 1958 in England, and that was copied in virtually the same terms throughout the common law world outside of the United States of America, and I'll make a comment on that in a moment. And our Ontario Act is the same as the English Act, with one important change in the description of one of the groups. Well, there's several little changes, but one important change in the description of description of one of the groups on whose behalf the court approves. I want to go back to my first point. The Variation of Trusts Act effectively acts as a supplement to the rule in Saunders against Vaudier. The purpose of it, I think, is clear, is to enable variations to be effected in cases where the rule in Saunders against Vaudier cannot be operated to do that. Its chief purpose is to enable the court to approve on behalf of persons who can't approve on their own behalf. The obvious categories are people who are infants, people who are not mentally competent, people who are not yet born, or otherwise not clearly ascertained as beneficiaries under the trust. So the court approves on behalf of certain, there's actually 4 classes of beneficiaries. That's the first point. The second point is that in general the Act does not permit the court to override the wishes of adult beneficiaries. So that's another sense in which it's a supplement to the rule in Saunders against Vaudier. You've got to get their consent, and then you get the court's approval on behalf of those who can't consent for themselves. I say in general because one of the interesting features of the Act that has only really become clearly apparent in the last few years is that there are circumstances where the court, it appears, can override the wishes of adult, competent, ascertained beneficiaries in the context of Category B in the Act, and I'll comment on that later. The third fundamental point is that although the Act is expressed in discretionary form, it says the court may if it thinks fit, then it goes on. There's one word that is crucial to the jurisdiction of the court to approve, and that's the word benefit in subsection 2. The court cannot approve a variation unless the variation appears to be for the benefit of the persons within any of the first 3 categories. The 4th category is taken out of the requirement of benefit. So benefit is the crucial word, and I'm going to comment on that particularly. So that's the basic scheme of the Act, and that's the background to the Act. A couple of very quick comparative points. 2 jurisdictions in Canada, Alberta and Manitoba, have, in their variation of trust legislation, modified the rule in Saunders against Vaudier. Well, in a sense, they've abolished the rule in Saunders against Vaudier because court approval is required for the termination of a trust in those jurisdictions, even when all the beneficiaries are adult and competent and agreed as to what they want to do. And the court has an overriding discretion to approve or not to approve that, based on whether or not the court considers the arrangement is of a justifiable kind. An interesting sop in those jurisdictions to the intention of the founder of the trust. The final comparative point is back to the United States of America, which is extremely interesting in this context. The basic point is the rule in Saunders against Vaudier does not apply in, I believe, any of the jurisdictions of the United States of America. It's also interesting that it used to apply in the early days, and the English cases, including Saunders against Vaudier itself, were applied until some point in the 19th century, when a contractarian, a laissez-faire philosophy strengthened the notion that a trust is essentially a deal, and the deal is between the settlor or testator and the trustee, and it's not for the court to upset that deal that has been done, if to do so would frustrate the material purpose of the settlor. And so that's the fundamental doctrine still in the United States of America, and they consequently have not got anything equivalent to our variation of trust legislation. It's interesting that David mentioned John Langbein in the context of his piece, because John Langbein also wrote an article in the Yale Law Journal called The Contractarian Basis of the Law of Trusts. And it's fascinating. He doesn't make any reference to our rule in Saunders and Vaudier, our variation of trust legislation. But his whole thesis is that the trust in America is a deal, a contract, in effect, between the settlor and the trustee. That's a fundamental difference between the law as it's developed there and the law as it has developed here. Okay, those are the background comments, and now some comments on the particular topics that I said I would comment on. The first one is put under the heading in the paper of postponement of vesting. And what I'm getting at here is the question, can it be a benefit for the purposes of the variation of trust legislation for the court to approve an arrangement that does not accelerate the vesting of an interest of a beneficiary, but does the opposite, postpones the date at which a beneficiary becomes vested and entitled absolutely to the property or a share of the property in question? Now, I consider this a very important issue, important because it can arise quite easily, and secondly because it can have fundamental importance to the families and children involved. One reason it can arise quite easily is because it's a common practice, at least in older Ontario wills, even in cases where there are vesting dates for the primary beneficiaries. Let's say you have a trust that is for the surviving spouse for life, and then on the death of the surviving spouse to be divided in equal shares for the children living at that time, and then you have trusts providing for a trust of each share with vesting at certain ages in the children. Maybe just one age, let's say the age of 25, or sometimes tranches with vesting at different ages. That's all well and good, and that shouldn't give rise to problems. But what frequently is the case, and I think it's extremely poor drafting, but it's very, very common, is that there's then provision of a substitutionary kind for the issue of a deceased child. So it says that if any child has died before the surviving spouse leaving issue, then those issue take the share per stirpes that the deceased parent would have taken. Typically, or often, there's no trust applicable to that substitutionary provision in favor of the issue. And I know of one case where the vesting date for the children was the age of 50, but then there was this gift over for issue of a deceased child with no trust provision. And so you can get the circumstance of the grandchild of one child becoming absolutely entitled to their share of the fund at the age of 18, whereas their uncles and aunts have to wait to the age of 50. So this is something that can arise even in those sorts of wills in which the concept of postponement of vesting is part of the drafting of the will. Now, my reasoning goes this way. Firstly, benefit under the Variation of Trusts Act, it is clearly established, is not restricted to financial benefit. Secondly, flowing on from that, in some circumstances, other factors can outweigh financial benefit, so that it can be for your benefit to have something that is other than your financial benefit. Thirdly, there have been cases in which the courts have held that it was a benefit to one or more children to have a postponement of vesting. Now, admittedly, the cases of which I'm aware have rather special circumstances. One of them, a case I've discussed, is called Re Towler, and the mother, at a time when the age of majority in England was 21 and the vesting of this child's interest was 21, a few weeks before the 21st birthday, applied to the court for an order to vary the trust to postpone the vesting of her daughter's interest. She filed an affidavit in which, among other things, she said that her daughter was alarmingly immature and irresponsible as regards money. The court had some backwards and forwards as to what it was prepared to accept, and in the end did accept a variation under which the interest of the child was postponed from the age of 21 to the age of 30, with a protective trust, as it's called in England, meanwhile. Now, I have to admit that Mr. Justice Wilberforce stressed the particular circumstances of that case and the evidence of the mother about the daughter's personality. I frankly find it unfortunate if the law should force parents into taking that type of a posture in order to get a variation, which I'm going to be arguing will often, as a matter of course, be something that is beneficial. But that is the basis it was decided on in that case. The second case is one called Holt, and there's no suggestion there of the particular financial irresponsibility and so on. And the mother in that case simply expressed what I regard as the very sensible view that it's in general not a good thing for young children to come into large amounts of money before they're established in life. And that was the basis that she wished to have the postponement. The special factor in that case, though, is that the children did get some financial benefit from the arrangement as well, because as far as half of the fund was concerned, their interest was no longer postponed to their mother's life interest, which under the original terms of the trust it was. Now, my view is that it shouldn't need special circumstances. My view is that it is generally not a benefit for a child to receive a substantial amount of property at a time when that child is not established in life and in a career. And that is the proposition I'm putting forward. And therefore, it should not require a parent to have to say that their child is financially irresponsible. It's enough for the parent to say, my child is quite normal. But I don't consider that an 18-year-old should come into a fortune. It's been suggested, I believe by some, that the age of majority, being the legal age of majority laid down by legislation in Ontario, is relevant in this context and suggests a legislative position that that's the age at which people are mature enough to do everything, including receiving fortunes. My response to that is that the age of majority is an arbitrary age that relates to a range of civic and other responsibilities, but it says nothing about whether or not a person at that age is in a position where it's a benefit for them to become financially independent. Indeed, it's not even an age at which you can go and buy a beer legally. You've got to at least wait to 19 for that. Secondly, it's my understanding that it's the experience of of most professionals, my guess is just about everybody in this room, that it's virtually invariable that parents creating wills for the benefit of their children who expect substantial funds to be available for their children do not wish their children to become entitled at the age of 18. They consider that that is not a benefit for their children. Indeed, they consider it a detriment. They consider it a benefit to postpone that vesting to some other later age, and meanwhile to provide discretion for the trustees. So that's where I leave that with, in a sense, a plea that that position is accepted if it ever arises. The second point that I deal with briefly in the paper, and I'm just going to touch on today, is put under the heading of tax saving as a benefit. I think the arguments about this are pretty well known, and I think the article by Mr. Hayington, which I referred to at the bottom of page 10 in the footnote, summarizes very well the case law on this. I simply want to emphasize that, in my view, there is no basis whatsoever in the legislation, the policy behind the legislation, or in any case that says that a benefit derived from tax saving is different from any other benefit that may be obtained pursuant to a variation of trust. And it's subject to all the same considerations that apply to other benefits. As I've already said, financial benefit is not necessarily conclusive. Other things have to be taken into account. But the fact that it's derived from saving taxes is neither here nor there, is my suggestion. I believe that's what the cases say. So that's pretty quick on tax saving as a benefit. The next thing I want to go to is something that I think has been less well explored, and I think is fascinating. I've got it under the heading of approval on behalf of adult capacitated beneficiaries within paragraphs 1(1)(b) or D. Now, as I've said, I think the general understanding of the variation of trust legislation is it enables the court to approve on behalf of people who can't approve on their own behalves, and it doesn't enable the court to override the wishes of those who can. But that's not quite true when you come to look at it. And I think the best way to get into this is if you look at section 1(1)(b), that's the one I want to concentrate on, and then my example, and I'll try and bring out the point. On page 2, I've set out that part of the Act, and that's where we've got the 4 classes on whose behalf the court can approve a variation. And it's B that is the one that I'm now commenting on. So we have a class which is as follows. Any person, whether ascertained or not, who may become entitled, directly or indirectly, to an interest under the trust, as being at a future date or on the happening of a future event, a person of any specified description, or a member of any specified class of persons. So it's basically referring to people with contingent interests and people who may be entitled as members of a class which will be determined at some point in time. Now go to my example, which is at page 11. And it's a very simple example. I see, by the way, that in the text immediately after it, the example is where the bullet point is. The text immediately after it, I say the issue of X. In the second example, well, I'm sorry about that. There were 2 examples, and I took one out. So there's only one. The example is this. A trust provides that property is held on trust to pay the income to X for life, and on her death to divide the capital in equal shares per stirpes among her issue then living. And if there are no such issue, to divide in equal shares among the other issue of X's father. Okay, then the circumstances we have are that, and I've got this at the bottom of page 11, assume that X is still alive, so the life interest is still in being, but she's an elderly woman aged 80. I think that's elderly. She has numerous children, 6, who are what I'd call middle-aged, in their 50s. She's also got 7 adult grandchildren, 8 minor grandchildren, and as well as those issue of her father, there's many other issue of her father. Now, the question is, on whose behalf can the court approve, under Category B, a variation to this trust? And can they override the wishes of any such people if they're adults? Well, it seems to me that the entitlement of the issue of X is contingent on being alive at the death of X. So her children, who are likely to be the people whose interests will vest at that time, in fact have contingent interests of a kind that brings them within, it seems to me, category B. So for that matter do the grandchildren, because of course it's possible that a child could die leaving children who would step into the shoes of their parents. So they are within B as well. So also are the other issue of X's father, because it's possible there could be a terrible disaster to X and her family, and all of her people are wiped out, and it's the other branches of X's father's families that become entitled. Now, I want to raise this issue from two different perspectives. The first is a practical one, and that is when you're doing a variation of trust in this situation, whose consents do you get to the deed of arrangement? Now, if you look at this very rigorously or very conservatively, perhaps, you might say, well, perhaps we should get the consent of every adult person who is ascertained as a beneficiary under this trust and who is competent. And that extends to all of these issues of X's father, because they're all beneficiaries, all of those who are adults and competent, and get them to sign off on this document. Now, that is often an extraordinarily time-consuming business of getting all those people to sign off, and you can get problems in tracking people down and so on. So that's one question. Do we have to bother with anybody who's got a contingent interest, and if they're adult and competent, or can we just assume the court approves on their behalf? Now that sounds pretty reasonable to say, well, you don't have to bother when it comes to the other issue of X's father, because chances are they're never going to get an interest in this trust, and half of them live in Australia and so on. But what's the difference between their position and X's children? There's nothing in the Act that distinguishes according to how remotely contingently entitled you are. By the way, in the English legislation there is. That's where there's a difference. There's no difference between them. So it's very difficult to say why you're getting the consent of X's children, but you're not getting the consent of X's grandchildren, and not getting the consent of X's father's grandchildren, except for extremely pragmatic justifications. Then look at it from the other perspective. Assume that you get some holdouts, somebody who says, I'm not going to agree to that. I don't like this, and anyway, I'm just not bothered with it. I'm not going to agree to that. On whose behalf can the court approve and override their wishes? Now, again, it looks pretty reasonable that you should be able to override the wishes of X's father's issue, who are these remotely, never actually going to get an interest sort of people, even the grandchildren. But to say you can override the wishes of X's children seems actually, frankly, incredible. But it appears that that is the effect of the provisions. And that, by the way, is the view that Professor Waters has expressed in the Law of Trusts in Canada. And that is the view that has been taken in the quite different, and this is interesting because it ties in with, from the different side, David's comments, two pension trusts. And the question in two pension trusts was, in BC, whether or not it was necessary in dealing with surplus entitlement, which was done under the variation of trust legislation there, to get the consent of every possible member who could have an interest in that surplus. And the BC courts have held that no, you don't. The court approves on their behalf and can override the wishes of even adult, capacitated, ascertained people if their interests are purely contingent. So that appears to be the law. Now, I think as a practical matter, one should, in doing a variation, get the consent of people like X's children, in my example. And in any event, the court, in its discretion as to whether or not to approve, is probably going to be intensely interested in their views at any rate. But it appears you don't have to go around finding every person who could possibly have some interest, like X's father's issue in my example. So that's a point I really wanted to bring to people's attention, because I'm not sure it's one that is always thoroughly understood. The next point, I guess it's my final point, is put under the heading at page 15 of refusal by the court to approve a variation even where a benefit is established or even where a benefit is not required. I've already told you a finding of benefit is fundamental, goes to the jurisdiction of the court with regard to approval on behalf of any of the first three classes, not required with regard to the fourth class. But that doesn't mean you've necessarily got the approval. That's just a prerequisite. So the question is, can the court refuse to approve even when benefit is shown for the benefit, let's say, of unborn and minor beneficiaries? Well, it's clear that the court does have some overriding discretion, because it says the court may, if it thinks fit, approve. So there clearly is some overriding discretion. But courts have gone beyond that, and there's two ways in which they've done it. Firstly, a position has been taken, and I outline this at page 16, that the court isn't even allowed to approve a variation if it amounts to a resettlement, or what Mr. Justice McGarry called a change to the whole substratum of the trust. So you can make relatively small changes, but you can't change the whole thing, to put it a bit more vernacular. Now, I find it surprising that that position was taken, because if you look at the wording of the Act, there seems to be nothing to justify it. It refers, if you go back to page 1 and 2, it says, well, just page 1 is just the discretionary bit, but then you go over to page 2, that the court can approve any arrangement by whomsoever proposed. Then it goes on to say, varying or revoking all or any of the trusts. Sounds to me as if the legislature was trying to find language as broad as you can get in order to give maximum flexibility to enable any variation to be done. And that, by the way, is consistent with it being a supplement to the rule in Saunders against Vaudier. Because if the rule in Saunders against Vaudier can be used, then everybody can terminate the trust and create a new one, if they so wish, totally different, if that's what they wish. Nevertheless, this position has been taken that the Act doesn't justify such a wholesale change as a change to the whole substratum of the trust. And, excuse me, that's where it stands. We have some cases saying that, but I think it's open to an appeal court in Ontario to take a different view of that. The next thing, and I'll just say this, and then, actually I'm not over my time, am I? Because he went over his time. Yeah. The next thing is the intention of the testator or settlor. And there's an overlap here, by the way, between the point I've just mentioned and what I'm now discussing. There are cases, and the main case in Ontario is the case called Re Irving, a decision of Mr. Justice Irving, where great regard is paid to the intention of the testator or settlor, to the point at which I think Mr. Justice Pennell suggests the court cannot override the basic intention of the testator. He uses various metaphors. He uses what I call the fruit tree metaphor, that you can prune the tree, but I don't think he says this, but you can't chop it down. You can't disregard and override the basic intention of the testator. Now, again, I don't think there's anything in the legislation that justifies that. It doesn't say that at all. And again, it's contrary to the role of the Act as a supplement to the rule in Saunders against Vaudier, which clearly does enable beneficiaries to override the intentions of settlors and testators. That's what the rule's all about. And this is a supplement, it seems to me, should also, in appropriate circumstances, when benefit is shown when needed, the court to approve of that being done as well. Clearly, intention is relevant. The intention of the testator or settlor is relevant as a factor to be taken into account. And as I've said, the court does have a discretion. And therefore, that can be taken into account. But that's as far as it goes. Now, there have been a number of recent cases which come, what I would say with respect, is the right view, and have emphasized that intention is simply a factor to be looked at by the court, but in an appropriate case to be overridden. And I've reviewed those cases at some length in the material, so I won't go over that again, except to just point out to you that the last one I mentioned really is the leading one now, although it's not an Ontario case. It's a decision of the English Court of Appeal in a case called Golding against James, where there's a very careful, detailed examination of the variation of trust legislation and the role of intention and the role that the court should pay to the intention of the testator. And that's a case where the court completely overrode what the testator wanted. No question about it at all. That's what it did, and it did it on the basis that that was the right thing to do. And let me just finish with one case, going back to a case that I mentioned earlier on, a case called Remnant. It's another English case, but it's been applied in Ontario. That's a case where a testator created trust for the benefit of his children and included a clause that was discriminatory against Roman Catholics, and basically said that people will lose their interests if they are or marry Roman Catholics. Now, when he did that and when he died, one side of the family was Protestant and the other side of the family was Roman Catholic. At the date in question, I'm not sure whether this is open to question now in England, it obviously is in Ontario, but at the date in question, clauses of that kind were clearly valid in English law. So there's no question about the validity of the clause. Very soon after the death of the testator, both sides of the family, the adults, applied for a variation. And the idea of the variation was essentially to take out the discriminatory clause. There were some other financial benefits as well, for the Roman Catholics. But the court held that the variation should be approved, the discriminatory clause removed, and did so despite what is the obvious. I mean, people don't put clauses in like that unless they really want them. And that intention of the testator, in my view, clearly appropriately, was flouted by the court's approval of the arrangements. And in my view, quite rightly so. So, that's the end.
Thank you, Tim. Your comments are always insightful, as they were today. Certainly leads us to give another thought to a lot of the current case law. I thank you all very much for your kind attention. It's been a long day and a lot of great material, I think. So a round of applause for all of our speakers and to you. And for those of you who are coming tomorrow, there's another full day.